I welcome all BB members and today's speaker, Mr. Ankit. Today we are going to discuss on guidance on valuation process in IBC, which is very, very important for us day-to-day IBC process in valuation. Like we have the guidance note issued by Company Secretaries Institute or Chartered Accountant Institute on various matters like how to do the value, how to do the audit, or how you have to consider the different accounting standard. Whereas we don't have any guidance note till now on valuation under IPC, which is very, very important. This guidance note consists of appointment of valuers and information sharing with the valuer, carrying out valuation process, valuation report, and consideration for liquidation process, and practical issues and suggested solutions, and format of appointment letter, approaches and methodologies, caveats and limitations. As you know that, once we accept the IBC valuation, we'll be having different challenges from gathering information and discussing resolution professional. Even the resolution professional may not be knowing the information since he is the new person to the corporate debtor. And also, as you know that even once we accept the case, like the quotations will be received by the resolution professional, where we have to give very less quotation. Afterwards, again, we feel that we have given very less quotation, the work what we are doing. There are a lot of challenges, even in inventory valuation also, and especially in real estate valuation. And again, investment in different companies by the corporate debtor. See, in normal valuation, the investor and the company will be having into different understanding, shareholders agreement, and we will be knowing. Whereas in IBC, our valuation report will be reviewed by the committee of creditors, resolution professional, and bankers, and even in some cases NCLT. And our valuation will be depending upon successful of whether plan is going to be successful or not. Because you are the, again, like all values, not only SFA, even whether it is plant and machinery or land and building valuer, you are going to determine whether the company is going to be successful or not. And we have to keep in mind a lot of things in valuation, whether the resolution applicant will give that value or not. Just like that, even if you give some 4 crores, 5 crores, the resolution applicant may not give that value. Then the plan will not be approved by the COC and NCLT, and again company will be going to liquidation. That means valuers will play a good role in valuation. It's a very challenging role. Now I request Shilpa to give welcome and start this meeting.
Good morning, everyone. I hope all of you have downloaded the PDF what has been circulated in this regard just now. Guidance note issued by ICAI, IPA on this best practices in valuation under IBC. It's my privilege to introduce today's speaker, Mr. Ankit Goyal. He is a founder partner at AAA Insolvency Professionals LLP and AAA Valuation Professionals LLP. He is managing partner at AAAG and Company LLP CS. He is a director at AAA Capital Services Private Limited and advisor for AAA Legal Professionals LLP. He has conducted 300 financial valuation assignments in the past 10 years. He keeps updated knowledge of the IBC law and regularly provides consultation to operational and financial creditors. He has completed more than 500 statutory audits in his firm. He is a regular speaker for insolvency, valuation, and forensic audit subjects at various forums. In fact, he's a veteran in this subject. We are privileged to have you here in our platform, Mr. Ankit. Over to you.
Thank you, Shilpaji. Thank you so much. And thank you, Mr. Subbarao. Indeed, I would give all the credit for this session to Mr. Subbarao. As soon as these regulations came in, I think Mr. Subbarao was the first person to reach out and say that, yes, this has come out and this is very important for the valuation profession. So let's have a session on this. So I believe it is indeed important to understand draft regulations, draft standards. And this one is the first draft that came in for the process that maybe is proposed by IIIPI. IIIPI is an organization which is an IPA under the IBC mechanism. So this is their document which they have taken out, that this is their model code of conduct in a way for valuers as well as insolvency professionals. So today, I believe we would talk from both angles or both sides, that yes, because this relationship is a very, very delicate relationship where the valuers are required to work with another professional. They are not working with another company or a management. They are working with another professional who is also doing his job, who is also having his own challenges, and so do valuation professionals. So I think I did prepare a PPT, but the PPT is more or less uh, more or less the same document that that basically is the original document which has come in. So let me try and share the original document itself so that it will be easier for everyone to relate to the same. Just configure my screen. Just give me a second. So we'll keep the format very simple. I will, of course, last thing I would want is to have a monologue, but at the same time, let's try and restrict our questions and our discussions on the topic at hand. And I will try to structure it in such a manner that we would know that what is coming next, so that we can ask the relevant questions that comes in. So this is how this document reads. It is triple IPI, that is the IPA of ICAI, and basically they have talked about background guidance on valuation process under IBC, and they have said best practices. So after reading this document, again, this is a draft. So even after it is released as a final draft, the guidance, unless and until it is given some teeth through regulations or through other mechanism, may still be a guidance based on best practices. It does not become a standard. So that is the difference between a guidance and a standard. In case of a guidance, you can still deviate from that guidance as long as you have sufficient reasons to do so. So this is how the contents are structured. They talk about valuation, they talk about appointment, they talk about information sharing with the valuer. So this part is very important, and this is one of the most important challenges of the IBC process. The insolvency professional is normally struggling to get information from the management or from the company or from the creditors, and therefore the information comes to the valuer in such piecemeal basis, and after so many rounds of reminders, that this part is an important list that has come out. Carrying out valuation process, they talk about the process, they talk about the valuation report, what should be in it, what should not be in it, considerations for liquidation process, practical issues and suggested solutions. Many questions that they have answered directly. So they have kind of prepared an FAQ for IPs and valuers. So I think that's an important part of this document. Specimen format of appointment letter for valuation. So this is again a format that I believe will help insolvency professionals in making sending out the right message to the valuer when they're appointing a valuer. Approach and methodologies for valuation, I would say most of us would already know these, being valuers. They have just summarized them. Caveats, limitations, and disclaimers, again, is basically coming in from mainly the guidance note that was released on caveats, limitations, and disclaimers by IBBI. And that guidance note, of course, is still valid. That in this document in no way kind of overrides that document. However, that document was for all valuation reports. However, this guidance note is specifically issued for IBC related assignments. So let's go forward and understand what they start with. They talk about, of course, a preface or an introduction to valuation. So, of course, they talk about how Aswath Damodaran talks about valuation, that it is not backed up by a story, is both soulless and untrustworthy, and that we remember stories better than spreadsheets. So, basically, the idea is that story or no story, the point is that a valuation report should be robust, should meet the standards, and maybe also attempt to meet these guidelines. That would be my interpretation. Today's dynamic world, of course, everyone wants to know the worth of the valuation. So basic introduction, then they talk about how valuation can be required under various aspects or various litigation, tax liabilities, etc., etc. Various use case scenarios that they talk about, including fresh issue and transfer of shares, business combination, mergers and amalgamation, employee stock options, IBC, financial reporting, and so on. So then they talk about, of course, objective of valuation under IBC. And there they say that valuation exercises, of course, we all understand it's a one of the most critical activities under IBC. And those of you who may not be aware of it, I can just say that again for the sake of repetition, that the valuation process that is done under IBC, that valuation process uh, is the guiding factor behind the COC's decision to accept a resolution plan or reject a resolution plan. So for example, let's say the liquidation value in its matter is 25 crores, and during the resolution process, the highest plan that the COC gets is say 20 crores. So there, the COC can still decide to proceed with that resolution plan. There is no bar on it. But then at that point in time, there will be it will be requiring a very high level of justification, and that is normally very difficult for banks to manage. The second thing that's important here is that when we talk about any resolution plan, there is a fundamental system in the resolution plan which says that one, the resolution applicant in his resolution plan has to give the value which is due to the dissenting financial creditors and the operational creditors. So two things happen. One, operational creditors are not even part of the decision-making process during the insolvency process. Similarly, related financial creditors are not part of that process. And financial creditors are part of the process. But at the same time, in case financial creditors decide to go ahead and approve a plan with 66% voting, they can't say that we will not even allow or we will pass a resolution plan which does not give the liquidation value to the dissenting financial creditors. So the liquidation value becomes important even because of that reason. Because in case your report, let's say, give an example, you're a company which you're valuing under a CD, a corporate debtor which you're valuing, which is under CIRP, and they say the secured or there are various secured financial creditors, and different secured financial creditors have their security on different assets. Let's say one person has lent out, or one financial creditor or one bank has lent out 10 crores to the company, whereas the mortgaged asset has a liquidation value of only 1 crore rupees. And on the other side, let's say that the other financial creditor has a 2 crore rupee outstanding balance, but has an asset of equivalent value, which is securing his loan. So in this kind of a scenario, if we purely go by the voting share, the financial creditor A will have 10 by 12% votes, and the other one will have 2 by 12% votes. So in that scenario, the law protects that person who is having a lesser value outstanding, but has a security against that asset. So in this scenario, in case that person wants to dissent, he will get the full value of his security before the financial creditors who are approving the plan can get anything. So this way, you would understand that how important IBC is. So, of course, the guidelines, of course, talk about under the Insolvency and Bankruptcy Code, valuation of assets is one of the core features, and how the RVs are required to be appointed. Then it talks about the 3 asset classes and how the 3 asset classes. So, by the way, this standard also deals with how to distribute the assets between the 3 asset classes, and we will discuss that at length as we go there. So the key objective is to be transparent and have credible determination of value of assets to facilitate the comparison and informed decision making by the committee of creditors. So what is the primary requirement of asset valuation here in IBC? The primary requirement is that one, information may not be available, may be available. It is possible that that balance sheets may not be prepared for the last many years. Therefore, a valuation will help ascertain the value of assets. Also, the value of assets that we are trying to determine in IBC is supposed to then be matched with or rather, the resolution plan tries to resolve the issue of how the assets can be used for the purpose of meeting the requirements or meeting the outstanding balances of the creditors. So then it talks about the importance of accurate valuation under IBC. It says valuation report guides the actions of the IP, COC, and NCLT. Fair value and liquidation value are frequently used by IBBI for statistical purpose to gauge performance of IBC. A registered valuer typically competes with market and endeavors to estimate a value which is more authentic than price of an asset. Valuation report is common cause of dispute for financial or operational creditors and may cause delay in the CRP process. Difference in facts between two valuation reports can be trouble for IRP, RP, and few of the possible effects of under or overvaluation is as under. So possible effects of undervaluation would be abnormal gain or possible abnormal gain by resolution applicant or promoters of the company, loss of realizable value for financial and operational creditors, possible loss of reputation for registered valuers. Possible effects of overvaluation would be rejection of resolution plan, which could have been approved, delay in liquidation process due to requirement to repeat process. So these are the possible effects, and this is the importance of valuation. So before we go forward, if there's any query on what we have talked about so far, I'll be happy to take care of that. I have seen that there are some questions already on the chat box, and so we will talk about who should do the inventory valuation. Liquidator has audited financial results prior 4 years. Can valuation be done with that audited financials? Yes, audited financials available for prior 4 years, I think, are historical financials. Valuation can very well be done based on that. So I will go forward. If there is no question, no query, then we look at they talk about the types of valuation under IBC. So they talk about fair value and they define fair value. However, I feel that in this entire document, there has been no comparison of these definitions with the ICAI valuation standards. Briefly, yes, or IVS is almost absent in the entire document. However, in case we talk about, because this document is coming from a body which is aligned with ICAI, I understand that there might be a perspective behind it. But at the same time, because most insolvency professionals and most RVOs have adopted IVS, I would say that if we are interpreting IBC and the valuation system behind IBC, then references to some IVS related provisions would have helped the understanding of valuers, especially those who are following IVS for their as part of an RVO. Also, one big problem is that any entity which is registered for multiple asset classes, it is difficult for, or rather impossible for that entity to get registered with ICA RVO. So invariably what happens is that because the entity is registered with an RVO which has adopted IVS, the entity has to adopt the IVS and can't adopt ICAI valuation standards. So that limits the usability of ICAI valuation standards, especially for larger assignments where maybe RVEs are being appointed. So fair value definition is stated here, and it has been discussed later. It has not been discussed here in types of valuation. So my only comment here is that in case you look at this definition, it is very similar to the definition of market value, which is the basis of value as defined in IVS 105. IVS 105 also beautifully explains market value at a very good length, and rather discusses each and every aspect of the valuation in a very detailed manner. So the two ways, fair value and liquidity and market value, I feel are different. Are one, the valuation date in the fair value definition in IBC is clearly stated as the CRP initiation date. So that is something that is different from market value definition. In the market value definition under IVS, it simply says on a valuation date, but here it defines and fixes the valuation date to the CRP commencement date. So we need to be conscious as valuers that if we do a valuation under IBC, under CRP process especially, we have to take care and make sure that our values of fair value as well as liquidation value have to be on the CRP date, and we can't say that okay, we will take the or give a value on a different date. The second difference between fair value and market value definition is that fair value definition in IBC only talks about valuation of assets, whereas the market value definition under IVS 105 talks about liabilities as well. So these are the two things I feel is important here. So then we talk about liquidation value, and we talk about the definition of liquidation value as stated in the CRP regulations, which again says that it is the estimated realizable value of the assets of the corporate debtor if the corporate debtor were to be liquidated on the insolvency commencement date. Then it talks about when a corporate debtor is under liquidation, the term liquidation value may refer to a valuation of assets when the seller is compelled to sell, wherein a reasonable period of time is given to find a purchaser less than the required marketing period. So they have tried and differentiated the liquidation value from, or rather defined it as some place where the the seller is compelled to sell within a reasonable time, but less than the marketing period. So they have kind of said that whenever you're deriving a liquidation value, you would try and understand that yes, there is a lesser marketing period available as compared to the normal marketing period. Then the said definition in its bare reading indicates that the liquidation value is a notional realizable value of the corporate debtor's assets if the corporate debtor's assets were liquidated on the insolvency commencement date. Then characteristically an asset can be different value under different scenarios. So they leave this open, that the asset can have different value under different scenarios. One thing that is perhaps important to understand here is that in our understanding, in my understanding, maybe this can be understood as a personal opinion, the liquidation value has to be your means in the entire process. That in case you look at the liquidation regulations and you look at how liquidation happens under IBC, the idea behind this definition in CIP regulations, in my opinion, is that if IBC would have been invoked, liquidation would have been initiated on the CIP date itself, then what would have been the value which is realized from the sale of the assets at that, on that liquidation or on that date when the liquidation would have commenced. So here when we say estimated realizable value, or we talk about what are the basis or what are the changes that happen. So one option is that there is a value which is a fair value, which is the market value of assets. The other is that there is a liquidation value of assets. So how are these two different? So in my opinion, they are not only different because of the limitation in the marketing period, they are also different because the marketing budget is limited in liquidation cases. They're also perhaps different because the level of due diligence that somebody can do in case they want to find a market value, where, because in case you look at the definition that you just find, it says that it is after proper marketing and where parties had acted knowledgeably, prudently, and without compulsion. The fact is that in case of liquidation, where the sale is happening on an as-is where-is basis, in absence of electricity in many factories, one is expected to value or to estimate the value of a plant and machinery. So what is the level of knowledgeability, prudence, and so what is the kind of knowledgeability or prudence that we can expect from the buyer? So in absence of that knowledgeability or prudence, the buyer would naturally discount or buy the assets at a lesser value to de-risk or to provide for the risk element in the whole scenario. Then they talk about realizable value. So they talk about how realizable value has not been defined. Then they talk about how the insolvency professional shall note that the CRP regulations mentions the determination of fair and liquidation value, whereas the liquidation regulation mentions about the determination of the realizable value of the assets of the businesses under various scenarios of sale. So in any further note, it may be further noted, then they say that both fair value and liquidation as defined under IBC mentions that it is the estimated realizable value of the assets, and then it says that this gives an impression that fair value is liquidation value, which is not correct. I never interpreted fair value as liquidation value, but I think this is a good clarification. The estimated realizable value of the assets of the CD in case of fair value is considering a willing buyer and a willing seller after proper marketing, whereas the estimated realizable value of the CD is in case of liquidation is considering that the seller is compelled to sell given a reasonable time. Again, I would say that this premise may not be the only differentiating factor between fair value and liquidation value. Perhaps the the prudence and the knowledgeability factor is also important. And thirdly, one is expected to sell in liquidation or find the realizable value on an as is where is basis, which will also differentiate or which will also create a value differential between fair value and liquidation value. So
Yeah,
these
okay.
are additional differentiations. Yes.
Ankit, hi, Sanjay here.
Hi, Sanjay.
The question, I mean, in practical world, correct? When
Mhm.
we go and let's say that we are appointed as a valuer for a
Mhm.
company, and we got an asset, and we are talking about, let's say, 2 months back that we got to value it, or 3 months back, because the valuation date is given this
Yeah.
date we are seeing. How does it practically happen? Do we go and find out 3 different codes and then we say, okay, fine, this is a fair value, and we do our maths of a discounted value of that asset or future realizable cash flows and say this is the second alternative? So how does it happen in the real world? Because you've done about 300 valuations, as I heard. So probably you can share your practical experience of how.
So in the real world, let's try and bifurcate this. Let's try and talk about different scenarios. So for SFA asset class, if you look at the balance sheet, normally what we ask for is the CRP date balance sheet, and we say, okay, what are the assets which are on the balance sheet?
Correct.
And then we try and value those assets based on what is the realizable value from those assets in future, maybe the prospective cash flows from those assets, depending on what information is available with the RP. And
Correct.
whenever we are doing discounting, whenever we are estimating timelines for the money going to come in, we are always using the CRP date as the cutoff date for those valuations. When we talk about tangible asset valuations, it is very, very difficult to say that if I'm physically verifying the asset today,
Yes.
and maybe the CRP date started about 2 months or 3 months back, sometimes it is even longer duration. I have to assume, I have no other option but to assume that the condition of the asset was the same as on the CRP date. And then
Exactly.
when I look at the calculations, again, when I'm trying to make a compute, maybe a DRC at some level, maybe I'm trying to find the value of the assets or similar assets in the market and trying to put in obsolescence factor. On all those calculations, I'm taking the period up to the CRP date. So that is the only practical difference. Then in case we are talking about a company which is a going concern or which has a prospect of being a going concern, I'm very careful when I say that there is a prospect of a going concern. In several cases, we find assets which are not on a going concern as on the date of our visit, as on the CRP date, but we realize that the only option for this company's revival is to be a going concern. There is no way that it can fetch value in case it is sold on a piecemeal basis. So in that case, then you also give a value to that company on a going concern basis. And then when you're computing those values, when you're doing a DCF or you're doing a market study and making adjustments, then you use factors which are relevant on the CRP date.
Got it. So actually, it could be quite subjective. And how do you get challenged when we do these workings, or it's pretty much because they want to just close the issue, they don't challenge it at all, and they say, let's go ahead with the value.
See, I think valuation is anyways, whenever you're doing a valuation, you're imagining scenarios. You're trying to find out based on the historical facts, based on the industry scenario, you're trying to find out, okay, what is the probable future for this project, for this asset. So at some occasion, maybe you will find out that, oh, this plant and machinery is such an old technology that there is no way to sell it in the market, and it has to be sold as scrap. So the moment you determine that, then you're not going to the market and hunting for today and latest technology machineries and understanding the value of those machineries and then putting an obsolescence factor, because you can document in your valuation report that yes, I have studied and this asset has no value apart from the scrap value. So it is always subjective, because the assets that you're looking at, the conditions you're looking at, they all can be very, very different.
Right. Sure. I mean, you can come back. Sorry, otherwise we'll detract. Thank you for your input. Yeah.
Ankit, I have two questions. I mean, you mentioned about discounting. In certain cases, we might have to do the discounting. In which case, what discount rate do we use? I mean, do we use weighted average cost of capital? Since we are not valuing any liability, do we assume that there are no liabilities? There'll be, I mean, all the liabilities will be resolved, and accordingly, we do not consider the cost of debt. Question one. And you also mentioned about the realizable value. Do we not use a replacement cost method in while doing IBPA valuations, IBC valuations?
Yeah, so DRC is depreciated replacement cost only. So DRC is popularly used for plant and machinery valuations, for building valuations. Of course, it is absence or its use is limited in other assets. But these two assets, DRC is pretty regular. The other thing that you asked was that what do we do with respect to the discounting? So say you're valuing a thermal power plant. The thermal power plant is, say, on the valuation date, not in operation. And you realize that the stage of that thermal power plant is such that it can definitely go into operation after maybe some work that needs to be done to revive the plant. So you would try and estimate, a technical estimate would be required to understand that what period would the resolution applicant need or the IP need to fund that revival and put that plant back into operation. And then you would like to understand that, okay, what would be the capacity utilization in the first few years and how will that increase? So when you do all that and then you try and put a discount rate, you would normally just have an look at the industry and see how the industry works. So in case you say that thermal power producers normally would have, say, 50% equity and 50% debt, and that is the basis using which you can arrive at a discount rate. So because you have to take these assumptions, otherwise there is no valuation which is possible, because nobody is going to give you those projections in an IBC case.
Thanks a lot, Ankit. I mean, since there is a IBC, there's IBC procedure. Do we add any premium to the cost of debt or cost of equity, saying that it's more risky, or we take that into consideration in the cash flows itself?
You would not do that in the fair value concept, because the definition itself wants you to assume that there is no stress, there is no compulsion to sell, and you're required essentially to compute market value of the asset as on the CRP date. So while you're computing fair value, you would not make any additional discounts based on any limitation to sell because of IBC, because the definition itself wants you to compute the market value. But when you're computing liquidation value, there are two options that are available. One, you can imagine a completely different premise. Let's say you're valuing leasehold rights. Now, leasehold rights will have a value which is a market value, but the moment the company is liquidated, the leasehold rights will vanish, right? Because you can't have a tenancy right while you're in liquidation. or while you have already gone into liquidation, all those arrangements get terminated automatically. So in that scenario, you will have a scenario where the fair value of a leased asset might be a substantial value. However, the liquidation might be zero. So
Ankit,
you would
small query. Suppose there's a building and a leasehold property, and the leasehold has expired. So, okay, leasehold right will give zero value, but what is the value you give to the building then? Can we give a right?
whenever
Or do we assume that the prospective
depends on the lease conditions. So we have come across this challenge in many valuations where the land is taken back by the authority which had given the land on lease, and it had allowed somebody to construct the building. So the lease would normally have some provision on what will be the fate of that building or how the building will be compensated. The normal process in all these leases is that the building will be torn down, and then once the building is torn down and the land will be returned, and even the cost of tearing down the building will be borne by the lessee. This is the kind of provision that is normally there in the lease deed, which is highly impractical, especially in cases where there is a third party interest created on that building. So those complications come in, but I think we can discuss them at maybe another time. Let's try and understand more about what has been talked about in this document. It's a fairly long document, so let's try and take it forward. So appointment of valuers is the next section that they talk about. They talk about how the registered valuers need to be appointed. They talk about the different asset classes. Then they talk about how the company's registered valuer and valuation rules define asset classes. Then they give a sample prototype of a balance sheet where they talk about non-current assets and current assets, and they talk about total assets. So they talk about all the various assets that they can list down or think about listing here. Then they kind of try and classify this through this example where they say that for land and building, it will be land, building, capital work in progress relating to land and building, right to use assets relating to land and building. Then the asset classes, plant and machinery. So plant and machinery, furniture and fixtures, office equipment, vehicles. Then CWIP relating to plant and machinery, right to use assets related to plant and machinery. And the rest of the kitty they put into the SFA factor. With respect to inventories, they put in a star and say that joint efforts of tangible asset valuers and SFA values are recommended based on nature of asset. So what if the inventory is, let's say, the person or the CD is into the business of real estate? So in that case, he will have a lot of inventory, and maybe a lot of value of the entire company will be lying in the inventory because it can't be a fixed asset, it can't be anything else. So not sure if we should simply say that because it has been through this example shown as SFA, do we expect the valuation of that maybe an under construction project or project under development, or maybe even sometimes you can have finished inventories also. Do we expect then SFA valuers to value that inventory? Alternatively, in case the inventories you have plant and machinery spares kept as inventories, do we expect SFA valuers to value that? So there is always this big discussion that can happen on this, that can actually be requiring, can have different opinions. Non-current investments, again, they have said is an security or financial asset. So in many IBC cases, these non-current investments can be substantial values, and they can also at the same time be going concern entities or entities which in turn have an investment in a land and building or a plant and machinery. So in those cases, again, when you're trying to value those assets, maybe you will have to do a valuation or do that valuation using multiple asset classes at the same time. So again, this differentiation in different asset classes, why is it important now? I think somebody is, I will just ask some.
Mr. Rajesh, I had muted you again. I don't know why you're unmuting, and a little bit background disturbances. I request you to not to unmute yourself. Yeah, thanks.
So the question now is that how does this matter? So does it matter only in cases where the valuers are appointed for different asset classes, of course, it matters there, because in case you are told to value all the SFA assets as an SFA asset class valuer by an insolvency professional, and after you have done and after you have completed the valuation, he comes back to you and say that, oh, the inventories have not been valued by you. You're requested to value the inventories as well. Whereas when you are, as per your opinion, the inventory is falling under a different asset class. So therefore, I think at the assignment initiation stage or during the assignment also, clarity is required on this aspect. Secondly, why is this important is that now the regulations have been modified, and earlier the it was up to the IP to understand in case the valuations of the two different registered valuers appointed in IBC process are significantly different. This significantly different was just written, and it was said that if RP is of the opinion that they are significantly different, he can appoint a third valuer. So somebody can say that, oh, these are 5% or different more than 5%. Let me find a third valuer. Somebody can so say, oh, these are only different by 35%. Why should I appoint a third valuer? So it left a room for error. So now what they have done is they have made modification, the recent modification that they did in September. And they have now said that this comparison will be done based on the values this comparison will be done on an asset class level. So SFA valuer 1 and SFA valuer 2, these two values will be compared, and then it will be seen that in case the values are different by more than 25%, then the third valuation will be required. Otherwise, valuation will not be required. So this throws out different problems. Now, recently we were doing a valuation for a real estate project under development, and we, understanding that that was the best way possible, computed the value of the real estate project under development using IBS 410, where it talks about computing the value using a residual method, wherein you more or less assume that if the project would be completed, then what would be the cash flows, what will be the cash outflows, and so on. So it's more of a going concern kind of a valuation, but for a real estate project or for a project under development. So we did that process, and the query came in that you have taken this as a land and building asset, whereas the other valuer has taken it as an SFA asset. What has been taken as the SFA asset? The receivables from the people who have purchased the flats. Whereas in case you use residual method, those receivables become part of the project assets and project value. So that took some time to kind of resolve. So these kind of issues, I believe, are there, and some of these will remain. So then it says that insolvency professional should study the balance sheet of the CD, and the valuer should be appointed keeping in view the nature of business, nature of assets held by the CD, size of the corporate debtor. An above table should be helpful for selection of registered valuers or specific asset class. For larger companies having various types of assets like real estate, machinery, manufacturing, financial assets, etc., it is recommended that IP should consider appointing an RVE. So this is how they've talked about it. Then it is important for an IP to check that a registered valuer can undertake valuation of asset only for the asset class for which she is registered. And then it talks about how the RVE list is available on the website. Then it talks about statutory provisions enabling the appointment of RVs. So I think I've already talked about how the 25% difference is now there. So this is the kind of how the whole process, or how Regulation 35 talks about significant difference and talks about how to measure that significant difference. So it would be in lines of what I've already discussed with you. Then the time for appointment. So of course, the appointment is required to be done within 47 days. So the structure of IBC is such that it is expected that the RP will, or the IRP, the interim resolution professional who is appointed by NCLT and starts the CRP process, will be either appointed as the RP or changed by the COC in the first COC meeting. and or after the first COC meeting. The first COC meeting is expected to happen within 30 days of the CIRP start date. So effectively, the timelines and how 47 days is calculated is that 30 days is that first month. Then they say that let's assume that 10 days is the time that NCLT will take to appoint the RP, and 7 days is the time that the RP will take to appoint the valuer. So this is how 47 days is computed. So wherever the RP is not appointed, because in normal cases, in most cases these days, because of the pendency and the backlog with NCLT, the RP appointment from the NCLT also takes some time. So if that takes some time, then the process the 47 days can go past. So in that case, what happens is that the IRP appoints the valuer by the 47th day. So that's the requirement that is stated in the law. Any questions on this? Whatever we have discussed so far, we can take that up.
Mr. Ankit, I request, let the discussion be more focused on
All right.
participants' queries also,
Yeah.
And whatever is simple and basic and all, you can jump and move to the
I will try and do that.
analysis.
I will do that. So best practices for appointment of valuation registered valuers. So it talks about the process of appointment, talks about invitation for quotation, wants the IRPs to call out for quotations to multiple registered valuers during the initial weeks of the CRP commencement, then deciding on the registered valuer. So he should use his wisdom to decide which registered valuer to seek the quote from based on the complexity and size of the registered valuer or the corporate debtor. Seeking the approval of COC, so based on we should seek the approval of the COC for the cost of the valuation process. So the normal process that practically happens is that you present the quotations or present the list of quotations to the COC, and then the COC, you ask them to pass a resolution for a particular amount. So the COC is not supposed to, or it is not required that the COC appoints the registered valuer. The IP appoints the registered valuer, but the IP has to have a budgetary approval for the valuer fee from the COC. So in case you get an appointment letter from under an IBC process, which says that you have been appointed as a valuer, but the appointment is subject to, or the payment of fee is subject to the COC approval of the fee, that means that the IP or the RP has rather appointed you to meet his deadlines, but he is essentially then looking at still waiting for the COC to approve your fee. So we have also seen cases where the appointment has come in and the negotiation on the fee has continued beyond the appointment letter. Appointment of registered valuer. So this is again something where 47th day I have talked about. This change in regulation that has been talked about in the background guidance is not adopted. So this was part of the discussion paper, but when the final changes have come in September, this change has not happened. So I think that everyone can make note of that there is no such sub-regulation 5 to regulation 27 in the present law. So I think it has been dropped and it is not going to come. Then confidentiality is what they want to bring in. So valuers and confidentiality go hand in hand. So I believe that there is not too much discussion that we can have on that. Compliance to regulation 27 of the CRP regulations. So it says that it is required, or it is important, that regulation 27 is followed. So regulation 27, since its starting days, has talked about how the registered valuer cannot be a relative of the resolution professional, a related party of the corporate debtor, auditor of the corporate debtor during the last 5 years, or partner or director of the insolvency IPE, of which the resolution professional is a partner or a director. So these are the requirements that one looks into. Then, of course, disclosure of relationships. So IBC process requires under this circular that all insolvency professionals file disclosures of relationships given by the IP as well as the professionals who are engaged by him. So therefore, the moment you will get an appointment letter from an IP, you would then be also asked by the resolution professional to give a disclosure in the format in the Annexure A. So that Annexure A disclosure is then required to be filed by the IP before the IBBI on their online portal. So moving on to the next chapter, information sharing with the valuer. So this is an important.
Sorry to bother. Sorry to interrupt. I'm sorry, actually. See, this regulation, the recent one, the regulation changes dated 29/2022. It talks about the timeline where it says that T+47, the valuer has to be appointed. And as you rightly said, most of the cases, because you said it is not mandatory, but the thing is that it talks about, the regulation talks about appointment of valuer. Though the IRP is changed, though the RP is changed from IRP to RP, he has to appoint that valuer. Is it right?
So I'm also saying that he has to appoint the valuer, but what I'm trying to say is that there is no guarantee that the COC would approve the valuer fee by the 47th day. Therefore, in many cases, what happens is that where the COC has reservations on the budgetary approval that the RP is seeking towards valuation fee, the RP will have to appoint the valuers with the condition that the COC is yet to approve your fee. I'm not saying the appointment can be delayed in any circumstance. The appointment has to happen.
May I come in?
Yeah.
Yeah. Just before this query, you were telling something about Form A. Just wanted to understand more on that. Who has to file it online?
That's the duty of the resolution professional. So the disclosure is filled in, signed, given by the valuer to the RP, and the RP then files that disclosure form to the IBBI.
Is it open for valuer to see whether this has been filed, or by any way is it a responsibility of a valuer to do it?
No, it's not the responsibility, but yes, you have to give the disclosure to the IP.
And can we see once he files it online?
There is some amount of public disclosure available on IPA website. So at times you can find that you will also find the names of the valuers who have been appointed by the IP, but you will not find disclosure of relationship online. Those are different disclosures that are filed at a different time.
Okay. Yeah, thanks.
A quick one, your experience when the appointment has been done, but COC has not confirmed on the fees, and later on they don't agree and they reduce the fees. What recourse valuer has other than but to accept whatever fees has been done?
Not much of recourse, I would say, because in case the COC is not ready to pay you the amount that you have quoted and you're not willing to do the work for that fee that they are seeking and somebody else is, then you can't go to any forum and say that I was appointed, but I am now de-appointed, although there is nothing which kind of, there is a good protection to valuers once they're appointed. But the only challenge comes in that if the COC has not approved the financial expense, that then the whole regulation do not allow the RP to pay that amount to you. So he can only pay the amount that is sanctioned by the COC.
Sir, what I had been doing where I am RP and wherever I am advising others also, I put it specifically in the appointment letter also to be reconfirmed by the RV that in case COC does not approve of this amount, or they approve a lower amount, then is that acceptable to the RV? And I take kind of say advance acceptance from them.
Yeah, so that's what I'm saying, that the appointment letter would say that you're appointed, but this is the conditional appointment based on your acceptance of the revised fee, or acceptance of the fee, or your quoted fee is still under acceptance. So that para can be written differently by different valuers, different IPs, but end of the day, it would mean the same thing. That yes, it can be renegotiated, and in case it is not acceptable, then somebody else can be appointed. But in most cases, we find that only in maybe 10-20% cases it is revised. Otherwise, the fee is normally accepted. So let's move on. So information sharing with valuers. So yeah, information. Yes.
Sorry to interrupt. So Ankit, the situation is that a CRP 180 days are over and the CD has gone into liquidation. NCLT liquidation order states very specifically that it should be sold as a going concern.
Yeah.
Now, when IP comes to the RV, okay, if I talk about a very broad view of the balance sheet, it has intangible assets and it has fixed assets and current assets. Now, as a going concern and being an RV for a SFA asset class, how will I do the valuation as a going concern? Because there will not be any projections as such, right? Because it's going to be get liquidated in a year or two. So any inputs, suggestions on that, please?
I think I briefly mentioned that projections or making projections normally falls into the hands of the valuer in this case. In your case, you have to be clear with the RP on whether you are responsible to do the valuation of the complete entity as a going concern, because that has to be given to one asset or one of the asset classes in case you're working only for one asset class. In an entity, it is not difficult to determine that, yes, who will do the going concern valuation. It is normally a joint effort between all the three asset classes valuers. But in case of individual valuers are being appointed, then sometimes it can raise some difficulties or some assumption difficulties. So I think that once that clarification is done by the RP that you are the person responsible to give a going concern valuation, then you can proceed with preparing the projected balance sheet or projections and take it forward.
So those projections actually
slightly
should come
different,
from IP, right?
Sorry?
The projections, as you said, they should be actually, that input should come from the IP. Am I correct?
Though this document, let's see what this document says with respect to information sharing. And I think the question here is that whether RP should give you projections or not. So let's understand what this document says and then take it forward. So we are anyways on information sharing with the valuers. So this one is talking about how the regulations talk about access to books by the RP and how the RP is supposed to have access to the various documents. Then it talks about timelines for completion of the valuation process, how it requires timely action. So then it says that the 135 day of the commencement of CARP is the date which is the outer limit, because that's the day on which the resolution plans are received, and that's the day when the CUC can have access to the valuation reports and then take a decision on how they want to proceed forward with the resolution plans that have come in. This discussion paper where they talk about how the code would talk about regulation for receipt of valuation report by IRP-RP is again not adopted. So the recent regulatory changes did not adopt this change. So there is nothing which says in the entire regulations that T+90 the valuation is required to be completed. Then we are moving forward with the liquidation. So again, in liquidation, it says that since asset memorandum is required to be submitted within 75 days of the liquidation commencement date, the valuation requirement under liquidation is required under 75 days. However, our experience with liquidation is that the liquidator normally wants the valuation report within a week or within 10 days at max, because the liquidator is interested in trying to sell the assets earlier, because the liquidation fee that the liquidator gets is based on how soon he has been able to liquidate the assets and realize the money, and how he has kind of the quick process allows the liquidator to get better fee. Therefore, the expectation of the liquidator is that you do the valuation, complete the valuation ASAP, number one. Number two, also that the liquidator, since he has access to all the documents from the CRP process, he would normally have the information which would be required by the valuer readily available with him, and he would take very less time in giving you that information, unlike the CRP process. Best practices in sharing the information with registered valuers. So it talks about how it is recommended that the RP or liquidator should start collecting the information data required for valuation exercise from the initial phase of CRP liquidation. And usually RP liquidator faces challenges of collection of information. Therefore, RP liquidator may collect the available data on the basis of best effort from corporate debtor, creditors, public portals, etc. Then valuation is a continuous exercise, and therefore continuous coordination should be ensured between the RP liquidator and valuers to avoid any omission in sharing of information or to update valuer upon occurrence of any major events. Authenticity of any valuation report depends upon the type of information shared with the registered valuer. Hence, the authenticity of documents shared with the registered valuer needs to be verified. So this is how the process is defined here. Then it talks about information required for valuation depends upon the varied factors such as nature of business, size of business, and so on. Then it talks about recent amendment where the creditor is required now to provide all these information. So this has been adopted. This regulatory change has already happened, where the corporate debtor is required, the corporate debtor's last valuation report, stock statement, receivable statement, inspection reports of properties, audit report, stock audit report, title search report, technical officials report, bank account statements, and all these information is required to be given by the creditors to the IRP or the RP. So this was a major contention that in case the management of the CD is not cooperating, why shouldn't the creditors give this information to the liquidator or to the IRP? So that has been resolved. Then they talk about a illustrative list and exhaustive rather, but not an exhaustive list, although I find it is pretty exhaustive. So inclusive but not exhaustive list of what information the registered valuers should be given by the IP. It talks about MOA, AOA, annual report for the past 3 years, audited financials as on the CRP commencement date, brief profile of the company, past project report, valuation report, TEV report, secretarial compliance documents, including ROC charge forms, sanction letter and mortgage deeds, financial projections, information about any special benefits. Then it talks about asset-wise or asset-wise information required. In case you look at this, you will find that it is pretty extensive, that what all information is required to be shared. So for PPE, it will talk about physical location, clarity about original revaluation numbers, fixed asset register as on the valuation date, property tax bills, rent receipts. So in most of the CRP cases, all this information or most of this information is absent. So the RP, but however, this list is an indicative list which can help the RP try and get as much as possible, and what is not possible is not possible. Capital work in progress and intangibles, it talks about a good list. Non-current assets, it talks about all the things, including investments made and so on. In case you look at intangibles, it talks about the potential projected cash flows associated with such intangibles. So therefore, the expectation is that what will be the future realization of the assets. Other non-current assets, it talks about various agreements and what is the nature of those deposits. Current assets, it talks about aging of the assets, provisions created, so for inventories, trade receivables, all that information. Cash and cash equivalents talks about cash certificate, nature of the balance, bank statements. Other current assets, it talks about the basis of realization, copy of ledger. So fairly detailed list, but at the same time, because it, I think, does not talk about a going concern basis here, it does not talk about specifically about if projected financial statement or projected statements are required. Now here it does. financial projections, business plan carried out by any third-party agencies, internal management for at least 5 years long with supporting assumptions. So the onus has been put on the IP or the RP to provide this to the valuer. Now, there are many IPs also in the house, and I would say that that will be a challenging task. So maybe if this is required to be given to the valuer, then maybe the RP will be required to appoint another professional who can try and estimate the projected financial statements and share that with the valuer. So again, not a very straightforward exercise.
So one small doubt.
Yeah.
Suppose as an RV, once I'm appointed, I'll give this list to the RP, saying that as per the I need.
This is an indicative IRL. Maybe some of
So,
these things will not be applicable, but yes, this is what we also do. Whenever we get the appointment letter, the next day we have a ready IRL. We send it that yes, this is the IRL, and normally we also customize it in case the financial statements have been provided by the RP. But where it has not been provided, we give a generic one. That's how we provide the IRL. We customize it based on the balance sheet.
And anyway, RP cannot give the entire information. So because of that, you will delay the process of valuation.
It will. What we try to do is we discuss with the RP on what all information is relevant and possible to be provided. Wherever the information is not, there is no foresight that information will come to the RP. There, we go ahead, take assumptions and close the valuation report. But where the RP is saying that I'm chasing with the bank and I'm asking the bank to give me the bank statements, and the bank will give me the bank statements. Please give me 1 week, please give me 15 days. Sometimes it takes longer as well. So in those cases, we have to wait, because in case we give a valuation report where even the bank balance as on the CRP date is not part of the valuation report, that what would be that report will be easily challengeable by anyone, right? That even the CRP date bank balance is not part of your valuation report. Maybe the books of accounts are not available, the ledgers are not available, trade receivables might be worth 50 crore rupees, but not even a single ledger is available. So in those circumstances, you have to still complete the valuation process, but you have to then protect yourself as a valuer and say that in absence of this information that I had asked for, I am taking the assumption that since the RP is not having the ledgers and the receivables or the details of the same, then who will be able to recover this amount in absence of even the ledger of those parties? So based on that, we give a zero value. We have no other option. So the closure has to be based on the assumptions in absence of documents. We can't say that we will hold the valuation report in case some information is not available. Therefore, in a scenario where the IRP says that I have no way of giving you the projections or the projections, and you give a valuation report saying that I am not doing a going concern valuation because I don't have projected data of this company, in that scenario, maybe somebody can challenge that valuation report and say that not even the going concern has been taken into account in the valuation report.
Ankit sir, in this case, if the projections are not forthcoming from the RP, in which case do we as valuers prepare the projections and accordingly disclose it in the valuation report saying that these have been prepared by us? Because I believe the disclosure would be absolutely required. So would it be a good practice for us to disclose this and disclose this and not take a concurrence from the RP?
We are doing that. We are valuing the company as a going concern is most important. We are doing that. There is no other way possible. And I would say that there are almost no cases in IBC that we have done where we have got these projections.
Would it be a good practice, or would it be possible from your experience that we interject here and we bring in the RP and seek his concurrence or acceptance to the projections and say that these projections have been done in concurrence with the acceptance of the RP?
We are sharing the draft report with the RP before issuing the final report. And in the draft report, we are, of course, including the projections and talking about the various assumptions that we have taken, which is the basis of those projections. So we are giving the final report to the RP only after his concurrence that these assumptions seem to be realistic or they are okay.
Thanks, Ankit sir. Thanks a lot.
So let's come to section 3, where we are talking about carrying on the valuation process. So suggestive steps that they're talking about is that the valuer needs to plan the entire valuation process in terms of time, effort, resources. He needs to review the appointment letter, understand the intended use, understand the purpose of valuation. So this part is important because liquidation regulations now, it's important for valuers to understand that liquidation regulations allow the company or the assets to be sold in the following 6 scenarios. That is, you can sell assets on a standalone basis, you can sell assets in a slump sale where you can club different assets together, you can sell a set of assets collectively, you can sell the assets in parcels. That means that in case you have a building having 3 floors, you can sell those independent floors separately. You can sell the corporate debtor as a going concern. You can also sell the business or the businesses of the corporate debtor as a going concern. So the idea and the understanding the purpose of valuation, there might be different premises that are possible, different possible future outlook that is possible depending on which of these following scenarios is the scenario which would allow or which would be most suitable for the case at hand. So in case, say, we talk about a power plant which is completely constructed, ready for production, but not under production, then I think none of you would agree that it will be possible or it should be possible or the liquidation would fetch a reasonable value in case you sell the assets of that power plant on a standalone basis or on a slump sale or on a collective basis or in parcels. I believe the assumption will have to be that the corporate debtor or the business of the power production that it has will be sold as a going concern. So when you take that assumption and when you look at that scenario of sale, then the assumptions change. Then you can't go ahead and do a piecemeal valuation of all the assets and give out a report. You have to then look at the going concern value and adopt the valuation approaches accordingly. So this part is important for all valuers to understand. So because what we do is we normally refer to liquidation definition under IVS or under ICAI, which sees that sale of assets on a piecemeal basis is liquidation value. Or it says that, so that piecemeal basis may not be true in an IBC case. That's what I wanted to say. Then, of course, it talks about orderly sale, or rather the different premises of orderly sale or forced sale. Then it talks about how definition of orderly sale itself says on an as is where is basis sale and so on. So understanding key information limitations, corporate debtor information relating to corporate debtor is important when determining the form and content. So then it talks about understanding the COC, the date of valuation, limitations on physical inspection, data availability, gathering the background information and submissions of information requirement list. So it then refers to the information sharing by the valuers. Due diligence for received data. So you do investigations, you kind of use your professional judgment, then you kind of, in case where credibility or reliability of the information supplied cannot be supported, then you kind of see how the information can be used. Documenting the findings of the study, you document that, you determine the valuation parameters, methods, you state the basis of valuation. Now, the basis of valuation which ICAI valuation standard talk about is fair value, orderly transaction, market participants, valuation date, all these things it talks about. But then, so I would say that when you talk about basis of value in an IBC case, the basis of value will be fair value and liquidation value based on the definition provided in the IBC. At least IVS says that in case the basis of value is defined in the regulation or in the rules itself, then that should be the adopted valuation date. So in this case, in case you're doing a valuation under the CIRP, then valuation date is never a question because CRP date is the valuation date. In case of a liquidation In case you're doing the realizable value computation during the liquidation stage, then again you are looking at the valuation, which is valuation date, which is a recent date. So similarly, then when you talk about market participants, orderly transaction, fair value, then it would depend from case to case on how you look at these values. Participant specific value, I don't think there can be any possibility of using a participant specific value in an IBC case. Anyways, it's part of the document, and I believe that that is what the IIIPI is asking us to consider.
The participant specific value may be, supposing there is a building which is specifically mortgaged to one particular financial creditor, so his liquidation value may be more than the others. No? So maybe that kind of a assignment of liquidation value to each financial creditor, that may be the intention there.
So liquidation value assignment to each financial creditor would not change the liquidation value because there is a participant specific value. Participant specific value will mean that because I am selling this asset, I am the seller, therefore the value will be different from what the market will perceive. Because in liquidation, you're supposed to auction the asset in the market and realize the value and give it to the person who is the secured creditor. There is no possibility that you can say that I have a compulsion to sell to a specific person. So anyways, I think there might be some use case scenarios for this as well, which I may not be aware of. Then it talks about premise of value. So premise of value in IVS is limited. Premise of value in IVS talks about highest and best use. Then it talks about the current use. Then it talks about orderly liquidation and forced sale. However, here they talk about a going concern value as a premise of value. I'm not sure, this is not again something which is aligned with IVS. And as is where is basis, premise of value as per IVS is the same as orderly liquidation. Rather, IVS defines orderly liquidation and says that orderly liquidation is where you are selling the asset on an as is where is basis. So these are slight differences between how ICAI valuation standards and IVS standards talk about basis of value and premise of value. So since we are actively following IVS and not ICA valuation standards in our RVE because of the regulatory requirement, these differentiations are something that are there. Then valuation approaches and methods it talks about, of course, we know market method, and income approach and cost approach approaches. So these approaches are common between IVS as well as ICA valuation standards. So they are perfectly okay. And all this is very, very right that more than one approaches. So this is exactly the same language, which is in IVS also. So there is no change there. Then it, of course, goes to an extra B and talks about the approaches and methodology broadly, which again we can go to. Caveats, limitations and disclaimers, it talks about the need for these and how the RV should adopt these, how he should talk about only his limitations. So there again, with respect to caveat, limitations and disclaimers, the guideline that has already come out from IBBI is fairly expansive. And I would say that that disclaimer also has regulatory teeth. So that is already in place. So this will always be the brief contents is always a summary of what has been presented there. Arriving at the first stage valuation is then the first, second, then the next step, evaluating the valuation. So as to arrive at the secondary evidence and empirical testing, drafting the valuation report, finalizing the report by revisiting it for completeness and accuracy. So this is how then the RP may adopt the procedure for getting a draft report, and this is how they kind of close this part. So coming to valuation report, we are short on time. So let me try and take it forward quickly. Valuation report, it says it's the final deliverable. Then these are the inclusions, and they say it is not an exhaustive list. So whenever you're preparing a valuation report as a registered valuer, one, you have to take care of Rule 8 of the registered valuers and valuation rules. Secondly, you have to take care of the requirements which are stated in the standards that you are following. So IVS has a long list of requirements that you have to make part of your valuation report. There is a dedicated standard on a valuation report on what is supposed to be in a valuation report in IVS. ICA also has a similar process. So it again talks about background information, title and executive summary, assumptions and limiting conditions, deliverables delivered through the report, timelines in terms of valuation date, report generation and submission date, approaches of valuation, valuation method applied, key inputs used in report, the estimates projections used in the report. So it talks about all that all this should be part of your valuation report. They're not interested in understanding if your valuation report is 30 page, 300 page or 8 page. They want all these contents to be part of your valuation report. Then it talks about considerations for liquidation process. So it briefly talks about Regulation 35, talks about who can't be appointed. So they kind of summarize and kind of talk about what all is required to be done in the liquidation process. And here they again talk about that how the Regulation 32 talks about that the liquidator is permitted to sell using these methods. And then it talks about A2F. And so basically, even if you look at the definition here, in 35B, it says that in cases not covered. So of course, in the first part, you use the valuation report that was issued during the CRP period. In the second part, where he can appoint a valuer, he says appoint 2 registered valuers to determine the realizable value of the assets or businesses under clauses A to F of Regulation 32 of corporate debtor. So when Dr. Sahu was the chairman of IBBI, I remember in the conference for valuers that we had, I got up and asked him that who is supposed to determine A to F? Is it the IP? So his response was that it has to be a joint exercise and he won't expect the RP to be responsible to tell the valuer that which of these scenarios will the assets be sold in during liquidation. Because the RP is trying to find a resolution, he won't know what will be feasible. So at times it is also possible that 2 scenarios are possible. So in those cases, we tend to give valuation or liquidation values for both those scenarios. So that's also something that we do. Then discussion paper dated 14 June on streamlining the liquidation process. So this has partly been done. However, the SCC which is constituted, or how so what has happened primarily is that liquidation was a process where creditors had almost no control. So then now they have brought in control through a mechanism where in liquidation, what is formed is the SCC, Stakeholders Consultation Committee. The Stakeholders Consultation Committee has now been given teeth that they can change the valuer with 66% votes. And at the same time, they have been given power that they can have meetings to talk about which professional to be appointed, budgetary approvals for the appointment, whether appointment of valuers is required under liquidation regulations or not. So all that has been already notified now in September, and that has become part of the regulation. Then let's look at this very important part where they have given a very interesting FAQ. So they talk about that what are the steps that an IP should undertake to assess the reasonable cost and sustainability of valuers with respect to size and nature of the assets. So they say that, okay, the step should be that relative experience of the RV in the valuation industry, past credentials, and analyzing separate quotes submitted by the RVs in conjunction with the above pointers. So all these things the RP should do. Then whether liquidation, fresh valuation should be obtained in case valuation exercise is already done during CRP. So then it talks about that, again, points out to the regulation and says that the liquidator does have the power to get the valuation done. And then it says that it should be encouraged to get a fresh valuation, as by the time the company goes into liquidation, as there may be substantial changes in the asset base. So it gives you kind of a recommendation that a fresh valuation should be done. But at the same time, talks about the basis of that argument, that if substantial changes have happened in the condition of assets, then a liquidation valuation can be done. But again, as I said, now this fresh liquidation, fresh valuation during liquidation now is also part of the agendas that which the SCC can consult or give recommendation to the liquidator on. So is IP supposed to review the liquidation valuation reports, or what precautions should an IP consider while accepting the valuation report? So IP should review the valuation report to ensure that it comprehensively covers all the assets. Then IP should also ensure that the details pertaining to related party transactions are adequately captured in the valuation report. IP should ensure that the valuation report follow the ICA standards or internationally accepted standards. So IP should ensure that the methodology, process, assumptions, etc. are appropriately applied for the corporate debtor. Then what shall be the validity period of a valuation report where IBC process gets elongated, or if there are substantial subsequent material events? So it says that the valuation report may continue to remain valid for the CRP period. However, if there are material events or CRP period is extended beyond 330 days, then the RP may approach COC for a fresh valuation. So industry-specific event that can materially impact the valuations of businesses may include instances such as shortages of semiconductor chips in automobile industry. So all these questions, they talk about how changes that can happen, how do we change that? Then this draft regulation.
So here again, one small doubt. Suppose the COC authorizes the RP to do a fresh valuation. Okay, because the period has crossed 330 days and all that. Will that liquidation value, whatever is obtained in the second process, second valuation, will it be considered as a liquidation value for all the bankers? That means operational credit as liquidation value, or that kind of things. Or it is only the liquidation value as on the commencement of CRP.
So far in the regulations, this change has not come in that a fresh valuation can be done. The fresh valuation is still not part of the regulatory process. So although the answer that they have said is that if it gets extended, a fresh valuation can be done. There might be some case laws or some litigation in NCLT which have kind of supported this idea, but we have not actively seen fresh valuations happen because if you allow fresh valuations to happen in an elongated process, then it can be a ground for changing the entire process. Anyways, this is how it has been stated, but I don't see how no regulatory change has happened to permit this per se.
Sir, isn't it that the valuation has to be done as on the date of the commencement of CARP?
Yeah, that's how it is.
So even if it gets extended, I mean, if the valuation process gets extended, again, we fall back to the date of commencement of CARP, right?
Yeah, so then nothing changes, right? Because you're still doing a valuation on the CRP date. So there's nothing in the provision so far which say that, okay, if the CRP extended beyond CRP period is extended beyond 330 days, you have to go for a revised report, and then the liquidation value and everything changes. So although that might be, it might be common sense to adopt that kind of a regulation, but so far we don't see that happening. So that was part of the discussion paper, but it has not happened.
Unless there are any facts which were in the, a kind of disclaimer or unknown in the first valuation report, there would not be any requirement for a second valuation.
No, in many cases, sir, in many cases, what happens is that, say, CRP did the valuation was X. So let's take an industry like an iron steel industry. Today, maybe the valuation is 2X for the same value because, prices have gone up, commodity prices have gone up. So changes can happen in a very brief time also. But then, of course,
shouldn't this be? I mean, shouldn't the valuation be as on the date of the CARP date, which is fixed? I mean, subsequent events.
It is like that. However, the FAQ talks about a different scenario and talk about how it can be done or should be done after 330 days. But what I'm trying to say is that based on the regulatory understanding, I have not seen revaluation happening, even if the process has gone on for multiple days.
Understood, sir. Thanks a lot.
So can COC members call for fresh valuation in case of revival of CIRP? So there is no specific provision in the code or its regulations giving power to COC to call for fresh valuation in case of revival of CIRP. However, there is no bar under IBC for the same. So again, I differ. My opinion is different. So there is a case law reference that they have given and said that, yes, this was possible in this case. But again, this case is an exception. Normally what we do is that whenever these days what is happening is that whenever NCLT revives a CIRP, it kind of says that now that we are reviving this CIRP, for all future purposes, this revival date will be deemed to be the CIRP commencement date. Because in case this does not happen, it brings in a lot of complications in the entire process. which anyone can imagine. So revival of CIRP cases these days, whenever that happens, the CIRP date is that new date only. So therefore, this matter is taken care of at that adjudicatory level only. Okay. So which type of disclaimers limitations are acceptable by IPs in valuation reports? So IPs may accept those disclaimer limitations which are where no document or detail have been provided. IP may accept disclaimer limitations which are outside the purview of scope of work. IP may also accept disclaimers which are agreed upon. Then it talks about note on disclaimers, which is again reference to the guidelines for CLDs, which I have already talked about. How to ascertain which class of values is authorized for valuation of inventory. So it says registered value shall be authorized based on nature of the business of the corporate debtor and asset being valued. For instance, if the business pertains to real estate, then valuation expert of land and building should be appointed for valuation of inventory. Now, in the FAQ here, the opinion is slightly different or can be interpreted differently from the opinion in the main text. So I think that's the kind of polishing that maybe is required in this draft document. But nevertheless, this is a relief that yes, the idea that we go out with respect to inventory is also accepted in this FAQ. What kind of intervention is required by user for determination of value by two registered values without interfering in independent status of value? So it says that if the RP is of the opinion that the value of the asset when valued is in isolation by the registered valuers will be impacted due to lack of understanding from RP, then in that scenario, RP can intervene without interfering independency of the registered valuer. Further, as suggested earlier, the RP may seek a draft report from registered valuer so as to ensure the facts, methodology, and assumptions of both the registered valuers are not materially different. So this is something that I completely agree with, that the RP has this duty to make sure that the assumptions, the information that has flown or gone to the RVs, it's common. The RVs have interpreted it in a common manner or in the best possible manner. So that way the engagement between the RP and RV is important, and the thorough verification of the facts, assumptions, methodology of the draft report is important to be done by the IP. What is irritating for valuers in certain situations is that when the RP calls and says that आपने ये वैल्यू दे दी है और ये वैल्यू तो ठीक नहीं है, मुझे तो हमें तो ये वैल्यू मिल रही है मार्केट में. Now that is, I would say, unprofessional. But at the same time, because the RP is also talking to another fellow professional, so there the scenario should be that the RP can always ask for the further detailing of that value. Now, let's say a land and building valuer has given a value and said that, okay, my market survey has told me that this land is worth 30,000 rupees a square foot. Now, there can be difference of opinion there. So the RP can always ask the registered valuer to state the basis of that market survey, talk about the comparative properties that he has got where this kind of value is appearing. So all that is all that is doable, but mere talking about the valuation amount, I would say, is something that should be avoided. It can also bring trouble to both the professionals. Whether difference in value has to be ascertained at consolidated level, class level, or asset level. So recent amendment, it says, has to be done at the so accordingly difference in value should be ascertained at asset class level. So this was earlier disputed, but or there were different opinions on it, but now it has been made very clear in the regulation, so there is no dispute on that. What should be the basis method of valuation for the following assets? So it says avoidance application filed by the user. So avoidance application can be filed by the RP under section 66 of the IBC, and it says that the valuer should independently conduct the valuation process of such transactions and highlight the facts for the respective transactions. So in our opinion, that when, say, an avoidance application has been filed by the IP and the avoidance application says that okay, there was this loan given to the director and the director has taken away this money without adequate consideration, so this money should come back. Now, expecting the valuer to give a value to that receivable is very difficult, because you're you're already approaching the NCLT and asking for adjudication on that matter and whether any amount should come in or not. So how will the valuer give a value to this avoidance application is beyond my understanding. And I always believe that as long as there is no asset lying in the balance sheet of the company which is linked to an avoidance application, saying that this is the value of an avoidance application by the valuer may not be possible. Then it talks about special assets like jewelry, diamond, aircrafts. In such cases, the valuer can consider the market approach. So they have talked about the market approach, but my question now is, or our question can be that who will value this jewelry, diamond, or the aircraft? So aircraft, maybe we can say a plant and machinery valuer should sign. But for jewelry and diamond, in absence of any asset class which has expertise in these assets, maybe the SFA valuer will have to do that in consultation with an expert. Share investments, especially when there is large valuation difference between book value and underlying assets and assessed value of underlying asset. So in such scenario, the valuer should seek necessary comments or reconciliation from the management for such large differences and arrive at the fair value based on the details provided by the management. Now, the RV in here, in my opinion, is not dealing with the management at all. He's dealing with another professional who is dealing with the management. So the RP, what we do is we try and do a KYC, we try to find out information available in public domain with respect to the subsidiary companies or those share investments. And then normally we find that when there is stress in the CDs entity, then there is also stress in the investee companies. And therefore the shares that are owned by that entity is normally valued very minuscule or have very minuscule valuation. So it does not really help in that respect. Then valuation of minority interest, controlling interest of downstream companies, again, book value versus financials. So here they say that book value may be considered in case where financial statements of the downstream companies are not available. But if financial statements are not available to you, the financial statements can be available publicly. So I would always recommend that you dig out those publicly available financial statements and then take a call. Whether a valuation report be shared with X management. So there is no specific provision to share it. And then it says that the confidentiality is crucial. Then it says also the X management is part of COC. So even though without the voting rights, and therefore excess of all documents shared in the COC shall be given to them. So here again, there is a case reference. So your valuation report in case of an IBC case will only go to the liquidator or the RP. It will not go to anyone else. That's the scenario. Would there be an action taken against a valuer if the valuer gives a different value at the time of sanction of loan and when valued as a stressed asset? So there would be no action against the valuer in such situations because the valuer is valuing both instances separately at different points in time. So they've said that the same valuer can take up both the assignments as well. Under what circumstances shall a draft final report number change? So there are generally 3 circumstances under which the final report number will change. So additional data has been received. There are changes in the circumstances where the assumptions taken need to be considered. Additional information was made available, which led to change in the valuation methodology. So the problem is that there has to be a change in these 3 things. Otherwise, the valuer can be pulled down for changing or making changes in the final report after the draft report stage. So until and unless these changes come in, the changes in the draft report and the final report are not considered to be ideal. Can an IRP RP assign a third person to appoint a valuer? So it says that the section says that the resolution professional shall appoint accountants, legal and other professionals in a manner specified by the board. Hence, it is explicit mandate of the code that it is a primary duty of the RP to appoint a professional. So he cannot delegate it. And they have also talked about that in a circular. So is the resolution professional required to get a fresh valuation done post COVID-19? So then it says there is no requirement for a fresh valuation. Resolution professional and COC will consider this COVID-19 scenario in the plan. So when the resolution plan or the resolution professional and the COC are considering a plan, and then they say that, okay, there is COVID, and because of COVID, we want to accept a plan which is of a lesser value as compared to the liquidation value, then they can consider it. It is open to them. Can an RP or COC interfere in a valuation exercise? So it says that valuation is a critical part and error, and hence it says that valuation needs to be conducted independently by the valuers without the influence of any stakeholders. So will there be any contravention where the resolution professional directed the valuer to value properties not owned by the corporate debtor but owned by the personal guarantee? So to conclude, it says that therefore directing the valuer to value properties owned by personal guarantor is in contravention. So you would only value properties which are owned by the corporate debtor. So in one of the cases, an interesting challenge came in that the books of accounts of the company or of the CD had an asset on record, but the assets title deeds were not in the name of the company. So it happens in some scenarios where the title deeds have not been made or not been transferred to the company's name. So in that scenario, we kind of then said that because the ownership is not with the CD as per the title deed, we will not be able to value that property as part of the CD assets. That is the submission that we made. However, we did recommend the RP that in case he can get a COC approval for separate valuation of that other asset, then that can always be done as a professional exercise, and the COC can consider that value as well when they are considering the entire valuation during the CRP process. Will there be any contravention where IP obtained approvals of COC for higher amount towards valuer fee than actually incurred? So it says that no, there is no problem. The COC can always approve, say, a fee of 5 lakh rupees, and maybe the valuer, maybe the RP can spend lesser. There is no gap there. How should a valuer deal in case of increase in scope of work? So generally, the code for valuation fees by the valuer is dependent on the limited information available about the company. And the best practice shall be to start the engagement with the information available. And when it is found that the scope has increased subsequently, additional information coming, the valuer shall seek additional fees. So in many cases, we have sought additional fees because of change in the scope of work, and resolution professionals have been kind to grant that additional fees, especially where the resolution professional had no clue that there was an asset which was available with the company, and later he realizes, oh, this asset is also available, and gives the information. COC also realizes that there is an additional asset that requires valuation. In those circumstances, additional fees is normally available to the RP. Then the company has already been valued under CIRP. However, it wishes to get valued again when under valuation. Under liquidation, can the same valuer issue a fresh valuation? So when a fresh valuation is required, then the best practice is to appoint a new valuer. Then it says that which qualities of value should an IP check before appointing them. So you should check integrity, reputation, character, absence of convictions and restraint orders, competence and financial solvency. I think if any of these three are damaged, then anyways the valuer is anyways not authorized by IBBI to work. So anyways, these are the qualities that the IP should check. Can a valuer be registered as a valuer for all asset classes? Yes, we have many valuers. We have enterprising people who are a one-man army where they are registered for all three asset classes. So, but I am not sure how somebody can certainly pursue the required education and become a valuer for all three asset classes. That is possible. Can a valuer be enrolled with two RVOs? So it says that they can only be part of one RVO, and it says that, however, for other asset classes, an asset can be. So you can be member of different RVOs, but you can't be so you can be member of different RVOs for different asset classes. That's what it says. So say you can be a member of ICA RVO for SFA asset class, and you can be part of, say, maybe some other RVO when you are looking at some other asset class. Whether and when a valuation report of figures can be shared with COC members. So I think this is part of regulation. It is part of the FAQ here, but it is part of the regulations that the RP can share it with the COC members at a particular time. When methodology techniques are uniform, are there chances for difference in valuation figures of same asset class by two different valuers? So even though methodology techniques are uniform, there may be a possibility of difference in valuation figures. I think we all accept that using the same assumptions, same methodology, also one can reach at different numbers. How can procedural delays be mitigated in valuation? So it says procedural delays can be mitigated by adopting checklist documents, which is required to value a particular asset or class of asset. Further checklists can be modified depending on the nature of industry or business. How to assess the value of assets? Assess the value of assets when the financial statements for the cutoff date is not available. So latest financial statement before the cutoff can be considered, and this is what we do practically also. So this is the end of this document. Now coming at the annexures, this is a specimen format. So it talks about overall outline should be provided for the appointment at the appointment time, where you talk about brief about the company, purpose of engagement. So this is the kind of appointment letter format that they have. And then they of course talk about the format for disclosure to be given as part of the appointment letter itself, so that the RV can return that disclosure immediately. So this is the disclosure format, which they have also made part of the process. Then approach and methods, I don't think we need to spend too much time on this, because we all understand that this is based on common understanding, based on the IVS or the ICA evaluation standards. So this should be all okay. All of us know this deal. So however, this putting it here will perhaps help the RP, some RPs understand the approaches that are possible or the methods that are possible. So that's there. And now in IVS, when we see, IVS does not talk about a net assets value method. It only talks about replacement, reproduction, and summation method. So there's some differences between IC evaluation standards and IVS, which I'm sure should be reconciled as time goes by. Caveats, limitations, disclaimers. I don't want to spend time on this, because this is again the guidelines that can be looked into. These are some abbreviations that they talk about. One more important thing that I think is important for us to understand while we are discussing all this, let me just dig that out and share it with you, is so there was another proposal that had come in the draft regulations, which talked about how the valuation report should be, or the draft valuation report should be discussed with the COC. So I think that has been again not been part of the regulations, final regulations. So we can take some questions now from the participants. I see many comments in the chat box. I think if there are any questions that are remaining to be answered or unanswered, maybe you can just unmute yourself and I'll be happy to take up those questions.
So if there's no other question, my previous question comes back. Suppose there's a leasehold land, and there's a building constructed by the company on that leasehold land. And later
I will share some examples where we have come across such situations. So there was this one case where there was this leasehold land which was leased from the Industrial Development Authority by the company, by the CD, and the lease was valid for say 10 years, and there was 2 years that lease had already expired in that case, if I remember correctly. And the lease allowed the CD to construct a building on that, and the lease said that in case the lease is not continued or the lease is cancelled, in that case it is the responsibility of the lessee to demolish the building and return the land to the authority. It also said that in case the building is not brought down, then the authority will take up the authority will have the option to either take over the building and give a mutually agreed value in return for that building to the lessee, or bring down the building and recover the cost of that demolition from the lessee. So this was, I think, a case which was in, if I'm not wrong, maybe Tamil Nadu was the state where this kind of an agreement we found. Then there are other scenarios. and those scenarios are also tricky, where the land belongs to the promoters. The land is held in the name of the promoters, and the promoters lease it out, maybe for a 30-year lease, maybe for some other period, to the company, and the company constructs a building on it. There, the land which is owned by the mortgager or by the promoters of the company is also usually leased out, also usually mortgaged to the bank as a guarantor. So the land is mortgaged by the or owned by the promoters of the CD, and again mortgaged with the bank, and the building constructed on that land is mortgaged to the bank by the company. So we have handled many such cases where there are a lot of judgments, and also the regulations have been changed to say that there is no limitation on a combined sale where the bank has access to land, and because of the relationship with the individual, the promoter, and the building is owned by the company. So both these are possible. I think with these two examples, maybe some cases would have been resolved. If, sir, the scenario that you are thinking of is not still covered, we can still discuss it.
Yeah, that's it. Thanks.
Ankit, see the challenges of what we have is that the RP does not have any confirmation of debtors or any confirmation of loans and advances, and he doesn't have the breakup of deposits. What are the deposits? The current assets being a big challenge there, and also there is a tussle for inventory valuation, as it is called for chemical and all. Who will do, whether plant and machinery or SFA? So these type of scenarios, how to resolve this?
We like, see the last part. Let me take that first. That the tussle in inventory between asset classes, I wouldn't say that in our entity there is no tussle. Even in our entity, we will sometimes fight between our partners that, okay, who will take care of this asset. But at the end of the day, we reach a conclusion, and the conclusion is normally based on the idea that in case the nature of the asset is such that the knowledge that is available. So one thing is very clear, that in case we are only talking about 3 asset classes. So in case the inventory has anything to do with land and building, then it automatically goes to the land and building value, and that is also something that we just read in the FAQs or in the questions that have been answered in this document. Now, coming to the tussle between the SFA valuer and the plant and machinery valuer. Now, in case I talk about inventories, in case I talk about gems and jewelry, nobody can say that the plant and machinery valuer has some background to understand the nitty-gritties of a gem and jewelry asset. So therefore, I would say that it will fall back as a financial asset and fall into the category of the SFA valuer. Similarly, let's say that there is a inventory which is lying in the factory, which is a work in progress inventory for a manufacturing process. Again, there can be a dispute. Somebody can say that it is scrap. If it is scrap, and if it is not having any other value, and there is no way that an SFA valuer can go out and say that, okay, what is the value of this item? In that case, maybe the scrap valuation should ideally be done by the P&M valuer, because he is the person who has specialized knowledge in understanding metals, understanding their compositions, understanding their scrap value, and finding out a value or giving a value to those assets. Then coming to spares for machineries, automatically goes to the P&M valuer. What else is there normally? Now, recently we were doing a valuation where we had the challenge to do valuation of 42,000 shoes, 42,000 pairs of shoes. Now, 42,000 pairs of shoes, can I say that the plant and machinery valuer has any specialization in valuing shoes? No. So that would automatically fall into the SFA category. So I think it's fairly clear that, you have to test that does the specialized knowledge of the land and building valuer or the P&M valuer allow him to do this valuation better than an SFA valuer? If yes, it goes to them. Otherwise, it comes to you. And this segregation, wherever the RP is appointing separate valuers, is more important, because in case you're giving it to an entity, the entity has to cover it here or there. There is no dispute there. But in case the other valuer appointed is independent valuers for different asset classes, then this clarity is important, because you don't want to, because your end of the day comparison between values is on an asset class basis. So it can change a lot of things.
So in that case, can we can you appoint a specialist and then rely on that?
So specialists can be appointed, but as the regulations say that even if a registered valuer appoints a specialist, he continues to be responsible for that valuation. Number two, in case you say take up the valuation of an inventory which is land and building in nature, then it would be wrong, right? Because you would be then appointing a land and building expert to do that valuation, whereas in the first place, it was never your asset class at all.
There are many challenges, even in I'm handling one mining case actually. So what is there in the mining under the earth? It is very difficult even for a land and building or plant and machinery SFA valuer. So I have to rely upon only a specialist who is in mining.
In that case, say there is a valuation for valuing the inventory of a coal stock. Now, a coal stock, there can be an argument that the plant and machinery valuer should know how to value a coal stock, but it is not a very strong argument, I would say. So in a case where we were doing the valuation, we did a volumetric analysis and tried to value a heap of coal that was lying somewhere based on how the market works around that valuation. And we had the option of appointing and taking an appointment, taking a opinion from an expert who is into coal valuation or who understands coal as an item. That was always open, but that would definitely increase your cost of that valuation.
My next question was the challenges in the non-availability of records in the current assets actually.
You have to do whatever is best possible. So you had talked about confirmation. So we have an interesting case there where we find in many cases there is a lot of inventory lying in these companies before they go insolvent. And then when they go insolvent, then they try to, because there is no inventory at all, and they're still showing it in the balance sheet, they try to sell this inventory to somebody. So in one case, what we found out was that there was this person who was standing as a debtor, and 10 crore rupees was receivable against that debtor. And the confirmation was also available from that debtor that this 10 crores is indeed due to you from me. And that confirmation was available on paper. But a visit to that debtor or a visit done by our team to that debtor, we realized that that debtor is living in a jhuggi, and he does not even have a owned scooter, leave alone the capacity to pay 10 crores. So a confirmation alone in an IBC case, in my opinion, is of no value at all. However, subsequent realizations that happen post the CRP date is very, very important to be taken care of. At the same time, the valuation opinion has to be based on what paperwork is available with the RP to follow up on that case and do some recovery in those cases. So in case he has ledgers, in case he has invoices, in case he has purchase orders, in case he has proof of delivery of any items that were sold to the debtors, then it is, of course, a valuation which will be an interesting valuation for the SFA valuer. He would then in no case say that the value is zero. He will have to go into every case, every debtor, and try and find out that, okay, this is the value that I ascertain based on the aging, based on the disputes, based on the documents available with the CD, that this is the value that will be realizable from these trade receivables. And also, of course, lastly, most importantly, the paying capacity of that trade receivable, of that person who that money is receivable from. In case you have a authentic claim against a company or against a person, but that company or person has no capacity to pay, then you have to discount that as well.
If projected financial statements are not available or provided to valuer, should it be mentioned or can it be ignored?
As I said, we are saying that we are making the projections. We are saying that the projected financial statements were asked for, not provided, and we have prepared these based on our understanding of this industry, our estimates, and we then give the value based on those projections.
Ankit, Sanjay here.
Yes, Sanjay.
You just now mentioned that we got to examine the 10 crore data example that you gave. Very interesting. In this situation, I mean, we are stepping into the auditor's shoes, correct? So do we go that beyond and say that, yes, we got to examine the capacity of the data and then arrive at the valuation, because then it will become a very strenuous and an extensive exercise where the data are varied. You can do ABC analysis also, of course.
I see it in a different way. How I see it is that at times we get a loans and advances list where we say that, okay, we have got 10 entities which total up to say 400 crores receivable from those entities. Now, one way is that I go through ledgers, I do a complete process, understand what is the amount recoverable from them. I tend to start from the other way. I first understand publicly what is the status of those companies, look at their financial statements, and in case in their financial statements or on the NCLT website or somewhere I find that those companies are also under stress. Maybe some companies are already under CIRP. Then, and maybe I realize that they are related parties to this entity. So if I document that they are related parties and that they are their balance sheet shows that this is the value which is available to the shareholders, do I need to really go into a detailed DCF analysis to understand the value of the investments, value of the loans and receivables, in case there is no value which is realizable from those companies in the first place? Because you have to understand that the order of priority that has been fixed now is there. So that order will never allow the shareholders to get any amount in case the company is into losses and has a huge debt to pay. Similarly, in case there are loans and advances given by related parties to that corporate debtor, to that person as a loan, it will never be realized. So what I'm trying to say is a primary analysis. I'm not saying you go in depth. Like many cases, that analysis is not even possible. Say you have partnership concerns, and the PAN number is not available for those entities. There is no way you can do any analysis out of those companies because there is no public data available. So nobody can expect that from you. But the moment there is a company from which that money is receivable, in case you say that, okay, based on the confirmation, based on the ledgers, I'm saying that this company 10 crores is receivable. But the next day you come to know that, oh, this company is also under NCLT and going under insolvency, then you will realize that your valuation report is wrong. That 10 crores will never be recoverable from that company because of the status of that company.
Yes, true. I mean, and that's a practical aspect of it. Very interesting. And then you have got to kind of write it off and say not necessary. Yeah. Thank you.
Could you please advise something on valuation of PUF transactions?
Valuation of PUF transactions. This document, of course, says that you should value them, but I think there is challenge in valuing them. At some occasions, what happens is that, let's say, let me take an example of PUF transactions. What are they? First transaction is a preferential transaction. What is a preferential transaction? That you have paid to a creditor on a preferential basis. So say you had the bank to pay, who had the first priority to be paid, but you have actually paid an unsecured operational creditor because he was putting a lot of pressure to you. So if you have made those payments within the last 1 year, or to related parties you have made that within the last 2 years, then that is called a preferential payment. So that's a transaction which you can go to the court and say that this is a preferential transaction, I want to reverse it. So when you say I want to reverse it, it effectively means that you will be asking the creditor that you have paid within the last 1 year to refund back that amount. Number two is undervalued, that is U. So PUF U is for undervalued. Now, in case of undervalued, you are saying that the asset is no longer belonging to the CD as on the CRP date. And is there then an expectation that you will still value that asset and make it part of your valuation report? That is the kind of understanding that we can understand that. So that is again a challenge, that how do you value an asset which is not even there or not even belonging to the company on the CRP date? In fraudulent transactions, there can be X limit of fraudulent transactions. So happening in the last 5 years, 7 years, we have done forensic audits in many cases for IBC and other cases, transaction audits. Expecting the value to repeat that exercise would not be perhaps a convenient expectation. Then we talk about extortionate. Extortionate transactions are again transactions where you say that somebody is giving me credit or giving me money on credit at an extortionate credit. So extortionate value. So somebody is charging you say 30% interest for the year. So one can say that that's extortionate credit transaction. Now, after understanding the meaning of this PUF transactions, can any valuer who is part of today's forum tell me that a valuer can value these assets or these recoverables?
So now what happens is already a case has been filed with NCLT, such and such transactions ought to be reversed, and the company is already under liquidation. Liquidator needs to somehow do away with those that particular case and accordingly move on. So that's how they get this valuation done, because I've done forensic audit for your entity. So that's how we are at times asked to do the valuation. And in one particular case, I did the valuation, and it had yielded some results as well. Some NBFC took it over, stress asset fund. That they took over that particular asset, and that's how the liquidation moved on. So I wanted to pick up your thought process around that.
So I've conveyed now that I think that it's a difficult exercise to be expected from the valuer. In liquidation cases, there is a possibility that the POF transaction or the applications have been filed and they can be valued by the liquidator based on the understanding of the applications filed. But in CRP cases, that by the time the liquidator or the valuer is expected to file the report, normally the avoidance transactions are still under identification. So there it may not be possible, but yes, I certainly agree that in liquidation cases or in cases where the application for avoidance transactions have already been filed with the NCLT, the valuer can give a value to that asset which might be available to the CD.
Thank you.
But in absence of the that application being filed in the NCLT, very difficult to repeat that process by the valuer.
I did the valuation when the company was under liquidation, and the application had already.
So in that case, then you would have documents or access to documents which would give you a fair idea on what is receivable and how to value that.
Absolutely. Thank you.
There's one
But in
question.
POF transactions, I have not seen any single case where there is a decision has been given and the amount has been recovered, or anyone actually, if anyone has done it, please explain me actually. So far, I know the last last 5 years, there is no realization of POF transaction. They are all heard actually, gone in the air. Please correct me if I'm wrong.
So I think that's out of syllabus, today's syllabus, but then yes, I think I also
I'm
agree
just
with
saying,
you.
since you mentioned about POF transaction,
yes,
I'm saying now no amount has been recovered.
I think we were talking about valuation of that recoverability. So I think that's something that we have tried to answer and how we can try to take it up. There was another question coming in.
Yeah. So this is all about the limitation that we have, that the information not being available, and sometimes RP does not also has access to it, and with respect to various aspects of the content of the financials. So is there a possibility to disclaim and not give a value, or resign as a valuer, or come out of the responsibility? Is that allowed in the law?
It is allowed. You can always resign as an auditor, but I wouldn't recommend it. I think you should simply say that yes, this information is not available, and in absence of this information, you would imagine as a valuer that no amount is recoverable against that asset, and a fair comparison between the values that you are putting in the financial statements or that are available in the financial statements and how you have given a value on what basis you have given a value in your valuation report is reasonable.
Okay, so there's not that we should
in case
you're
making an effort and then resigning as a valuer, then that would be nice, because your effort will all be wasted. You will not get any fee out of it. Giving the disclaimers, giving the assumptions, discussing the difficulty in the report, and then sharing the recoverable value as 0 would be a better approach.
Okay, there's another aspect of it, and in most of the cases we see advances to land being a very huge component on the asset side, on the current assets. So this is neither land or completely converted to be valued as a land and building valuer, but it comes under the SFA valuer. But most of the times
we normally tend to say that because it is an advance for land and there is an agreement which is giving some rights and some land or some property to the CD, we normally say that this should be part of the land and building segment, and we normally move it there and talk about the rights over the land or the building or whatever rights are arriving through that agreement in that in the land and building asset class.
Okay, thank you.
So I think there's I can share my mobile number and email address with everyone. I think somebody has put that on the chat box. Just give me a second.
Ankit sir, I shared privately.
No, it's okay. Mr. Ankit, you can go ahead. I request Mr. Ravi Shankar Devarakonda to formally thank our today's speaker on behalf of BVA.
Thank you, Mr. Ankit. Thank you for your time and sharing your knowledge and experience on this guidance note. It was really very, okay, I could have read it on my own, but then reading with somebody like you has given us a lot more benefit than doing it alone. And as you said, the entire valuation, the IBC process and also valuation are time bound. So you completed it well ahead of the time, because the way it was starting, we think it had to go. But then that gave us a chance to ask you more questions than, okay, relevant, not relevant, and all that, but everything is relevant to valuation only. And during the process, you discuss the whole of the document, and mostly it is pertaining to ICA valuation standards, not the IVS standards. But that may not make much difference, because both the valuation standards are 99% similar, except for one or two small definitions, which may come up only in a very rare cases. And most of our doubts are also clarified in that valuation stand in this document itself by FAQs. Who should value the land and building, or who should value the inventory, how to value the PFA transaction and all that. And on behalf of BFA, BVA will thank you once again for your time and effort in taking up this program. Thank you, sir. Thank you.
Thank you, Ravi Sankarji. Always a pleasure, and I always find BVA sessions most useful in whatever field they start with. And I think this session I don't know of any other RVO that has taken up this subject so far after so many days of this document coming out. So it's nice that BVA is, of course, taking the first step towards it, as always.
Thank you, Ankit. Okay, for immediately accepting our request and taking the session. I think the BVA members most beneficial for this topic. Thank you once again.
Thank you everyone. Thank you. Pleasure to be here today.
Thanks a lot, everyone. Thanks.
Actually, BVA has taken a step to come out with a handbook on DCF valuation. And we are seeking frequent, FAQs, whatever anyone wants to raise any FAQs, please raise it. A Google form has been circulated to all of you. Mr. Ankit, separately, I'll send that link to you.
Sure.
Okay. So if in case you give any question, the committee will check it out and publish the answer for that FAQs in the relevant chapter in the DCF valuation. So you have to identify the chapter also, and you have to identify your query. This is
Ankit, briefly, we are coming out with one book, like on DCF valuation, like every valuer can refer, like before going to do some, if a new valuer, if he comes to new valuation practice newly, he can verify, like how he can calculate the beta or enterprise value or horizon value, everything he can check. It is like a FAQ type DCF and with format.
Okay. Sounds good. I think I will like to go through it, and then I will certainly come back with my, it will be a learning for me as well to go through that document, and I'll come back to you with whatever I observe from it.
Yeah.
Thank you so much.
Thank you.
All right.